Thank you.
Recording stopped.
Good morning, colleagues. Welcome to our meeting today on the 1st of November, 2022. Let me welcome members here at M46, the members at the virtual platform. We have now have the required quorum. Those who were late have now joined as members on the virtual platform. I also want to welcome the public protector here at M46. Recognize evidence leaders, Advocates Bauer and Advocate Mayosi here at M46. The support staff, entire support staff with us, members of the media in their various platforms here and in their other platforms. And most important and lastly, the members of the public who are joining us from their various platforms. Thank you very much. Welcome you all to the resumption of our inquiry today. We concluded on Friday with the key decision that we could not proceed on Friday, owing to a discussion we had, but also the request by the public protector for more time to be given. The committee acceded to that request, even though not as would have been wished for, but for a limited period of time, and would have agreed that we'll resume today at 10, which is exactly what we're doing. We concluded in saying that today is going to be the leading of the last witness, and then what will be outstanding is the cross-examination of the two last witnesses beyond today, which will be Mr. Jane as well as Ms. Niels van der Merwe. I hope Mr. van der Merwe will be on the platform when he is needed. But before we get into that space, we then agreed that it will be important that we give the platform and the space for the public protector to give us whatever feedback that you would have had prepared for us. And therefore, for today, it would be important that we start there, because that is going to assist everybody. As we concluded, the public protector was very clear on the record that there would not have been any termination of mandate of a legal team, but was equally clear that she needed time to engage and hear out the legal team, to which we acceded. And so we are looking forward to get that briefing. We would have continued with our correspondence, and in brief, the public protector would have corresponded with her even yesterday and would have responded in saying that, confirming that she will be here and that detailed exploration will be done here in the meeting. I also would have corresponded with the legal, with the attorneys. We will hear that from the public protector, but maybe later on we can also flight the correspondence. Thank you very much, colleagues. Thank you, public protector, for being with us again. I now want to recognize you and hand over the platform to you. Thank you.
Thank you, Honorable Chairperson and committee members and everyone who's part of this process, evidence leaders and legal services from Parliament. I will take you through the update and report back on what transpired. As ordered by the committee, I have tried everything in my power to determine, clarify, reconfirm the situation regarding my constitutionally guaranteed right to legal representation in the Section 194 Enquiry and the position of my current legal team of attorneys and advocates. As repeatedly stated by me to the committee, it was never the case that any of my legal representatives withdrew from representing me or walked out, as incorrectly alleged by some members of the committee, the parliamentary legal advisor, and some sections of the media who are hostile to me. The legal practitioners merely implemented in the most appropriate manner available in their opinion and in the circumstances, the mandate which they had at the stage, which was only to deal with the postponement application without giving any recognition to the committee as presently constituted and until otherwise advised. So it is indeed so that due to the resultant confusion, misunderstanding and deliberate misinterpretation of what was explained, I was left in a position where the committee needed to know whether or not the legal representatives were intending to withdraw as incorrectly asserted by others. Hence, I made the request to be granted a week to ascertain the correct position, which was unfairly rejected by the committee, which gave me only 1 working day to do so. I now wish to report the progress available in such a short space of time. As far as the attorneys are concerned, although I've yet to be able to have a physical meeting, we discussed over the phone, we had a long consultation over the phone yesterday. And as well, they have sent you a letter as the chairperson. And accordingly, I can now confirm that as reported in the committee last week, they have not withdrawn. They are still my attorneys of choice, Sianeho attorneys, and I've instructed them to write a separate letter to the committee. And I hope that once and for all, that clarifies the position, which remains unchanged. And I must indicate that I think Mr. Sianeho will be on the platform. He's here, but Chairperson, he has a court or an engagement to attend. So I just said to him, let him just log in, and if given an opportunity, Chairperson can see him, and then he can excuse us because of the following reasons. I can similarly reaffirm that the advocates, they are still my team of choice as briefed by my attorneys. They remain in place since their brief has never been terminated by me or my attorneys. However, due to short time given to me by the committee and pre-existing commitments, I have not been able to secure a physical consultation with counsel. There is a tentative arrangement to hold an agent consultation upon their availability, either today in the evening or tomorrow, which is the 1st or the 2nd. So the availability of counsel, unfortunately, is that they are not available to attend the committee sittings today, this week, actually. These are the following reasons. Until last Friday afternoon, there were no scheduled committee meetings which were set, but then we know that the committee sent us the letter which was saying we were meeting 27 and 28. And for the week of 31 to 4 October, according to the revised program, there was nothing which was loaded by the Secretariat on the 20th of October. So they were not in a position to set up anything for that. But then what is critical is that due to the directions by the Chief Justice, which we've received on Friday, which I will also share with the committee, my counsel team is required to compile heads of argument by the 4th of November, covering no less than an unprecedented 7 different cases which have been consolidated by the Constitutional Court, all set down for hearing on the 24th of November. These cases are as follows: an application for leave to appeal instituted by the DA, an application for leave instituted by the President, an appeal by the DA, an appeal by the President, a confirmation application by the Registrar, a conditional cross appeal by the Public Protector, and a conditional application for leave to appeal by the Public Protector. And for ease of reference, I have also attached those two directives by the Chief Justice dated 14th and 28th of October, respectively. It will be observed that the chairperson acting on behalf of the committee is also a party in and therefore aware of the said Constitutional Court proceedings, which are of the direct relevance to the fate of the Section 194 proceedings. So an appeal record which was lodged by the DA on Friday, 28th October, consists of over 2,000 pages of reading, which will be necessary in the drafting of the required heads of arguments. In addition to all of the above, the team also has to finalize the judicial review application of which you were notified last week. This week was therefore reserved to deal with other pressing matters, especially what we've received and directed by the Chief Justice and necessitated by the rulings of the committee. You might be able to appreciate that it would be impossible to achieve those tasks and simultaneously do any justice to the last minute proposed sittings of the committee, which involve the cross-examination of 2 witnesses. The counsel team will therefore only be available from the week of the 7th, subject to all previous arrangements and requests regarding the duration of the remaining witnesses and the recalling of the witnesses. Needless to say, and in the very unlikely event that the counsel team may have indeed withdrawn, which I said they have not withdrawn, you would have indicated the last time that it would then require the whole process to appoint a new counsel or attorneys, but that is not the case. And that matter, I hope it has been clarified now. So the incorrect position that my right to legal representation is not absolute was argued and roundly rejected by the Constitutional Court when it unanimously ordered that I must be afforded full legal representation by the practitioners of my choice at this inquiry. In this regard, you are referred to the relevant judgment of the Constitutional Court. I think it was addressed by the legal services as well on Friday. In the event that the committee unreasonably decides to proceed in the absence of my chosen legal representatives, and in spite of the representations made above, I will kindly request that you provide me with the necessary reasons so that the decision be included in the series of reviewable decisions of the committee. Thank you, Chairperson.
Thank you very much, Public Protector. Maybe it would help for completeness sake to Tembingosi to just flight the correspondences that the PP had referred to, including her instruction for the CNECO to write a separate letter so that members can see that. I certainly have received that. Whilst you're doing that, I must just check if CNECO is on the platform.
Good morning, Chair.
Yeah,
Good morning, honorable members.
can you hear us?
Yes, I can hear you, Chair. I don't know if you can hear me.
Can you hear us?
Yes, I can hear you, Chair. Can you hear me? Chair, I can hear you clearly. Can you hear me? Chair?
No.
That is, we can hear you clearly, but I think the problem is with the chair there in the
That's
committee.
the
Thank
name.
you, Honorable Mauta. I can hear you as well. Chair, can you hear me?
Okay, let's check first. Maybe it's not his problem. Honorable,
Can you hear me?
Yes, I can hear you. Honorable,
can you hear us?
Yes.
No, Chair, I think the problem is in the chamber because we can clearly hear Mr. Sianejo and we can hardly get what you are seeing on that side. So can the ICT?
Okay, we're going to have to fix that. So the problem is not with Sianejo. So there's a problem of it's on your side. Okay, we're just quickly checking the system so that they seem to be speaking, but we can't hear them.
Yeah, it looks like it's a judge problem, this one, chair.
Ooh.
Don't start, don't start.
Ompi, I see Paulson here is busy handing over gumboots to Ndibi Modisa. I think we must call this one to a disciplinary hearing.
Hey, Chief, I've got your membership form ready. Please leave those things. Just come this side so you can be sober, Nyana. Hey.
me check. Honorable Ompile. Can you hear us?
Yes, Honorable Chair, we can hear you clearly.
Honorable Maotwe.
Chair, I can hear you. Can you hear me?
You're very far. It looks like you're in another country.
Okay, let me come closer to you, Chair. Can you hear me now?
Okay, we'll still try and solve it.
Can you hear me, Chair, on the other side?
Wait, man, wait. Chair is dealing with leadership here. Wait,
Chief, you're not leadership, man. What's the problem?
wait, man. Ngola, wait.
Do you know that the public is listening to us whilst we're doing this thing?
Yeah, we must relax. Chair is calling me, not you. What's your problem?
Well, I wanted to check if the problem is not your network. I know these things of Bundus. Check, can you hear me on the other side?
Only you.
So
Your
I
voice
can't-
is
That's
horrible,
fine.
Ngola, man. Yeah.
Chair, can you hear
Recording
me?
stopped.
Chair, can you hear me?
I think Chair and the House have gone. They're out of the platform.
I think the chamber general is a problem.
Yeah, that's the bundu. That's why the Parliament must come here in Gauteng, please.
That thing of Cape Town is a bundu, ne?
It's a big problem.
I won't share my views on this platform around that matter.
Yeah, but I know you agree.
Okay. Honorable Ngosi, can you hear us?
Recording in
Yes,
progress.
Yes, Chairperson, I can hear you.
Thank you. Now it seems to be working. Mr. Theo Sianejo, are you there?
Good morning, Chairperson. I'm here. Can you hear me?
Yes, thank you very much. We hear you very loud. Thank you.
Okay, thank you.
Let me just check this with all of you on the virtual platform. The public protector would have made a presentation. Did you hear her when she was making that presentation?
Yes.
Okay, thank you. So we've not lost that. Appreciate it. Thank you. And then I'm now going to ask Thembu Ngosi. No, I wanted to check if Mr. Sianejo is present. Then we go through the correspondence. Are you saying you're not ready? Okay. Good morning, members. Good morning, guests, members of the public and everyone present. The Public Protector Advocate Mkhwebane. Thank you, Chairperson. Chair, as you had rightfully indicated in your opening remarks, that there was a letter that went out on the 28th of October to Sianeho attorneys on the adjournment application and way forward. The purpose of the letter was to inform the Sianeho attorneys of the outcome of the adjournment application and way forward. Chair, safe to say that the full letter, in actual fact, all the correspondence that I'm going to be tabling here now has been shared with the members. In actual fact, the letters were shared this morning, just a few minutes ago, if members want to read through them. And then, Chairperson, on there has been email communication between my office and the Public Protector relating to assistance that we have offered in an event where PP would have challenges in terms of travel logistics. However, response was that PP has someone that deals with that, and it was taken care of. And as such a person, PP is sitting here in the meeting with us. And then, Chairperson, in that communication, there was also an email that the last email which we received, which is basically a summary of what the PP has now presented to the committee. And that statement that the chair presented this morning, she shared it with me, and I have shared it with the members together with the annexures that go with it, Chairperson. And the last one, Chair, was the letter which I received last night from Sianeho attorneys in response to your letter of 28th of October, where they indicated that on that letter, they indicate, Chairperson, that they had not withdrawn their services, neither has council, and that would also await further address from the Public Protector this morning, of which PP had addressed the committee. And on that note, Chairperson, that is what I had for now, and thank you very much. I'm going to ask you to fly to the Sianeho letter. It's a very brief letter, and then I'll just ask Mr. Theo Sianeho to say something on that. Thank you, Chair. On the screen is the letter from Sianeho. Can you read? Thank you, Chairperson. This letter, Chair, was received, as I had indicated, on the 31st of October, which is yesterday. It reads as follows: we refer to the above matter and specifically the clarity sought in paragraph 9 of your letter. We confirm that Sianeho Attorneys Incorporated acts on behalf of the Public Protector and never withdrew as her attorneys of record. We further confirm that we have not terminated council's brief on the matter. We are instructed by the Public Protector that the rest of the matters raised in your letter under reply shall be addressed by the Public Protector. Yours faithfully, yes, and that's it. Thank you, Chair. Thank you very much, Mr. Ngoma. Mr. Theo Sianeho, any comment you want to make? I want to give you an opportunity to perhaps to emphasize that letter.
Okay. Thank you, Chair. Good morning, Chair. Good morning, honorable members, evidence leaders. Good morning, PP, and everyone that is present at the inquiry. I guess I only have to confirm the contents of the letter because I think the secretary has already read it. We confirm that the letter came from our offices. As you know, Chair, some letters can be sent from fake emails. So I think we thought it would be proper for us to be here to confirm the contents of the letter instead of just sending a letter and keeping quiet. And also out of respect for the chair. Chair, thank you. I think that's all I can say at the moment. And
Okay.
Chair, as the PP has already mentioned, I would beg leave to be excused from this discussion, Chair, so that I can attend to other things.
It might, I've not seen you before. Maybe you have a network problem. Maybe for us to see you
Okay.
first before we
Yeah, I believe
get
you
to.
have.
Yes, this is Theo Sinena.
Thank you, Chair. Thank you.
Okay. Thank you.
Thank you.
Please stay on the platform. Just any members, you have had a presentation from the public protector and can switch off the mic. And would flighted the letter from Sianejo attorneys. Any comments or remarks you want to make as members on what you have heard? Honorable Heron and Honorable Mylam.
Thank you, Chair. Obviously, the clarity is, or the clarification on the way forward is welcome, but I really don't understand what happened last week. There's no explanation for what happened last week at all. But clearly, the attorneys and counsel are back on board, although there's a suggestion that they never really left. So that's the only comment I have, is that I'm still not sure what happened last week.
You're probably not asking the chair, or you ask.
Well, if someone wants
I
to
understand
explain
your
it,
dilemma. I
if
understand
someone
your
wants to explain
dilemma.
it, that'd be very
Well,
welcome.
thank you, Ms. Heron. I share your dilemma, Mr. Mylam, Honorable Mylam.
Thank you, Chairperson. Chairperson, I really only have one concern, and that is that the public protector and her legal team were advised repeatedly prior to the walkout on Thursday that, or whatever you want to call it, however we want to describe it, and I apologize for my voice, Chair. They were advised repeatedly that in the event that the application for adjournment failed, the committee would be proceeding with the witnesses. And they were advised over a week ago of that fact. So to come now and say that there was no prior notice that the committee would be meeting this week or next week or whenever it might meet is actually a bit disingenuous. In fact, it's not a bit disingenuous, it is disingenuous. And I think that part of the problem here is the difference between the public protector being, quote, entitled to legal representation and her legal representation actually being present. She can bring any legal representative she likes here now. Nothing's preventing her. This committee is certainly not preventing her from having her legal representatives here at the moment. So I think that there's a little bit of mischief at play here, Chair. Thank you.
Honorable Van Minen, Gondwe, and Hendricks.
Thank you, Chair. Yes, I just want to express my concern about the events of the last few days. It is completely so that the public protector, of course, is able to get legal representation of her choice, but it is concerning to me that she seems to have selected legal counsel that is either unwilling or isn't able to represent her the way that they should. And I think that that is something the committee should really express their concern about. Thank you.
Honorable Gondwe.
Thank you very much, Chairperson. Chairperson, like Honorable Heron, I still don't understand what happened around the walkout that we witnessed last week. And so I would just like them to explain why they actually walked out of the inquiry if they are still, representing her. I'm not entirely sure what the point of the walkout was. I just need further clarity. I mean, maybe I'm just I just don't understand what happened, but I think we deserve to know why they walked out. And Chairperson, like Honorable Milham, I remain concerned about these repeated delays. I mean, now they are asking for them to be able to proceed with the inquiry from the 7th. I mean, we'd have lost a number of days in between. And so I remain concerned, Chairperson, that time is against us, and we really don't have time on our side. And this is a committee with a lifespan, and really we need to make sure that we get on with our work, and all these repeated delays are really hampering what we've been set out to do as a committee. Thank you very much, Chairperson.
Thank you, Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I agree that there is mischief as referred to by other honorable members. And this mischief mustn't be allowed to derail the timelines that the committee has set. I hope, Honorable Chair, that you will be strong enough to ensure that we stick to the deadlines. So tough luck if cross-examination, for example, is reduced. The way I feel at the moment, Honorable Chair, is that we must do what they do in cricket, that we must just make a decision, refer it to Parliament and let them vote on this. It is my understanding as a layman that attorneys and counsel take instructions, and certainly they got no instructions to walk out. That shows contempt for their client, it shows contempt for the legal fraternity, and it shows contempt for Parliament. Thank you very much.
Thank you, Honorable Hendricks. Maybe the cricket thing, you didn't complete it. It's called the third umpire. There's a third umpire sitting next to a TV. And then there's what is called referral. I'm not sure it will apply here, but I just wanted to complete your example of the cricket. You can see you do watch cricket from time to time. Honorable Mautwe.
No, thank you, Chair. Chair, mine is very simple. We now know that PP managed to speak to a legal team to remain on board. So there isn't really an issue where we should be going back and say what happened, how is it going to assist us? We need to move forward. So now the issue that is on the table right now is that although the PP's legal team is still on board, but they are not available now. So what we should desist with us as committee members is to say, we can't continue in the absence of the PP's legal team. She just said now, I was actually trying to check the program, Chair. Maybe Tembinkosi can send it back, flight it back. Indeed, there was nothing scheduled for this week according to the program. So they had planned their work according to what the program of this committee says. So let's postpone it and let's then resume as per our program. But really going into stories of what happened, we're not moving anywhere. We're not taking us anywhere. Let's move forward. We are happy that there won't be any time delays, because it would have been a serious time delay if the legal team had withdrawn and PP had to start from scratch looking for new attorneys on board and the senior counsel. So let's all be excited that at least we won't have to go through that. But the reality is that for this week, they are not available. And PP is pleading that let's wait until they're available. In any case, Chair, as per the Concord judgment, we can't continue in the absence of the legal team. I heard Mr. Milham saying entitlement. There's no entitlement. It's an order by the highest court in the land that says she must have, it doesn't say she may, it says she must have a legal representation. So we can't be in contempt of court. Now, let's move forward, Chair. Let's schedule this meeting for the next day. I see your agenda is already talking about taking the other witness. It will be in contempt of court because we would be doing that in the absence of her legal team. So I think let's proceed like that, Chair. Thank you very much.
Thank you, Honorable Mautwe. Honorable Zungula.
Thank you, Chairperson. Greetings to yourself, the PP, honorable members, and everyone listening. Firstly, Chair, I think let us appreciate the presentation by the PP. The committee did give a task and she's delivered on a task, even though there was short turnaround times, but she did deliver. What I want to comment on, Chairperson, is basically that, in my view, it would be unfair that the PP is made to answer for the actions of the advocate. The advocate, when there is a session whereby the advocate will be here, I think all of the actions relating to the advocate conduct or actions of the advocate must be answered by the advocate. I think what was required by the PP of the PP, which is to indicate whether she's continuing with that legal counsel, she's covered that part. That is the one area I needed to touch on. The second area, Chairperson, is that indeed, as per the program, there is nothing that was scheduled for this week. And as you know, and including the presentations by the PP, there is the list of court cases in which the legal counsel has to prepare for. Unfortunately, it is cases that are in line or that are intertwined with this process, or the standing of the PP relating to her going back to work. So it would be, a miss of the committee to act or to position themselves as if those cases are not related to the work of the committee. And those cases are not even, because even the committee itself, yourself, Chairperson, is part of that, some of the court proceedings. Even our party as well, we do know these court proceedings. Then the last thing, Chairperson, I would propose that we let the PP and the legal counsel to continue preparing for those court cases, because it's very important that those court processes are not handicapped by the legal counsel having to be part of these proceedings, whereas they are equally important. Like it has happened in the past, whenever there's court processes that the legal counsel of the PP had to participate in, they were given off time to prepare for those court processes. So even in this case, the legal representative of the PP must focus on that court processes in order to be best prepared for those court processes. And in line with what the Constitutional Court had said, that the legal representation of the public protector is critical to make sure that this process, it is fair and it is balanced and there is justice. Therefore, I think we should not allow a situation whereby the committee does proceed without the legal representative of the PP, because by doing so, we would be somewhat undermining that that judgment of the Constitutional Court, which stress that the PP must be afforded legal representation in everything that is happening in this process. So if there are going to be parts of the process or parts of the inquiry that held without the legal representation, I think, Chair, in my view, we would be, undermining the Constitutional Court, and in view to be in contempt of that certain judgment. Thank you.
Thank you, Honorable Zungula. Honorable Suela, followed by Honorable Lagude.
Thanks, Chairperson. Greetings to Advocate Mkhwebana, to yourselves, colleagues. Chair, I don't have much to say rather than to say that we really appreciate the cooperation by the PP, but I just want to raise two issues. The first one, I think that has been the observation of the committee, that her legal team worked out. It's not something that we are fabricating. So I want that to be on record. That has been our observation as the committee, and it's a worrying factor from our side, and it should be also a worrying factor from her side, because it's a right to have such a legal team. Secondly, the honorable member who said we must not ask her those actions, she's quite right, but to indicate those observations as the committee, I think it is important, because even the senior counsel himself said to us that our mandate ends up here. So those observations need to be reflected, because it's what transpired, rather than to be seen as if we're doing something or we're trying to create something which was not there. But we appreciate the cooperation, and we also want to indicate that we can't deprive her to have legal rights, because it's a constitutional, it is constitutional that she must have legal representatives and not may. But at the same time, that time or the framework which has been scheduled to make sure that the proceedings are moving smoothly must also be taken into cognizance, because here we have set up some time frames, which I believe from today here is something which we need to indicate on how are we going to battle to arrive to that point. So my proposal, Chair, will be that, yeah, let's proceed, but let's try to schedule our program in such a way that we meet the deadline, because it is time consuming and it is also costly. So I think these are the two inputs which I wanted to make before this August House. Thank you, Chairperson.
Thank you, Honorable Swell. Honorable Dlagude.
Thank you very much, Honorable Chairperson. Good morning, colleagues, evidence leaders, and the PP. Honorable Chairperson, let me take this opportunity to welcome the presentation by the Public Protector, and also to thank her for presenting herself before this committee. Honorable Chairperson, while we heard what the Public Protector said in this meeting, and also what Mr. Sianejo said, we also, as this committee, acknowledge that constitutionally, the Public Protector has a right to have legal representation. That one we agree with fully, and we support that. As a committee, we also have work to do. And I believe that we are also protected by the very same constitution and also the rules of Parliament. Then we appreciate that her legal representatives have not withdrawn from representing her. But what I don't understand is, why did they walk out of this committee last week? That is the part that we do not understand. And we were left with only 1.5 witnesses that we were supposed to deal with as committees, so that we can move forward and the Public Protector be afforded an opportunity to present her own witnesses, and also for her to take a stand. So this is where the confusion is for this committee to move forward. If we can be clarified there, why did they have to walk out? Because for them presenting that application for adjournment, even if the committee rejected it, there was no need for them to walk out, because we're going to finish with the witnesses. Then we see where how to move forward from there. Thank you very much, Chair.
Thank you, Honorable Dlakude. Honorable Olomisa.
And morning to all. I align myself with those who say there should be no leading of any witness in the absence of legal representation. Secondly, the issue of the advocates withdrawing in the manner they did, I don't think is relevant for today's discussion. Chairperson, this thing is going to drag. I can see Guti. This needs go delay and go my is in a time frame as I adjust or in terms of what the public protector is. Finally, Chairperson, sikhulule mfondini ngoku. Siyongqwasha amahashi, siyophalisa phalaphala. Ayikho le nto, khona into enkulu ezayo. Ncede, Nkosi.
Thank you, Honorable Olomisa. I've heard you. We'll talk to that. To find permission here somewhere. It is our corresponder up.
Aye, yazala triggers.
Honorable Nkosi.
Thank you, Chairperson, and greetings to all members of the committee, the PP, and the evidence leaders. Chair, I have a question that I want the PP to respond to before I come with a proposal. And that really relates to her explaining what happened last week. I mean, physically, we saw people walk out. We saw the SC call the team behind him, whether it was Sianejo or whatever, I don't know. But he called the team out and they left in this meeting. So it's not something that we're dreaming about. We then engaged on a lengthy process to clarify what was happening. Clearly, at that point, our view was that there was a walkout. And that walkout was initiated and happened at the instance of the senior counsel. So until the public protector explains to us, she can't come back here and say that including Sianejo, by the way, that they have not withdrawn. What happened last week? Why were they not part of a meeting after hearing our decision? Why did they leave this meeting after hearing our decision? If they had not withdrawn, they would have continued to participate, or at least they would have indulged the committee to explain that they needed to confer with the public protector to determine any next steps or any way forward out of that very incident. And that would have afforded them at least an hour or 20 minutes to do so. But it did not happen. So I just need a clarification from the public protector before I come back on what my possible solution should be, Chairperson.
Honorable Ngosi, I will park you for now. Honorable Ngola.
Thank you very much, Chairperson. Chair, I think we all agree that there is no question over whether the PP shall be represented or not. I don't really get the point of repeating all that. But I think it is incorrect of the PP to say members incorrectly said her legal team marched out. And later in her submission, project that thing was actually a march out. Because as things stand, until now, if the explanation says the legal team did not march out, did not withdraw, what did they do? Nevertheless, Chair, it's fine. It won't help us to repeat that. But I think, Chair, it is incorrect to say members must not ask the PP on what happened, the behavior of her legal team. Chairperson, it is the public protector that is appearing before the committee. Whoever she brings as her legal team is her choice, as she said in the submission. So questions are going to be posed to her when there is a matter that needs a clarification in the committee. But beyond that, what makes it more difficult for the committee to arrive at a decision now is the PP says there was a consultation over the phone with the lawyers. Then there is a scheduled consultation with the council later today or tomorrow, I think so. But there is no specific time frame at which how will the committee cooperate with her need for a consultation and all those things? Because it can't be that we're going to wait as the committee for a period not determined. Because now we're made to wait until the legal representatives are in the mood again to come back. So I don't understand, that's where the confusion lies, that the committee must wait for an undetermined period. So I think if clarity can be given to that extent, so I think it will then shed a light on how then should we plan going forward from today. Thank you, Chair.
Thank you, Honorable Mola. Honorable Lothridge.
Thank you, Chairperson. My apologies for not switching on my camera, but the connection is not what it should be. Chairperson, I want to start with what was said just now. We have to understand this is not an open-ended process. There is a specific program, and I also have to take us back to there was a full program, which is then regularly updated as is necessary. But the dates have been set down already by this committee, and they are, even if they are tentative, they are there, and one would assume that you plan accordingly. Secondly, Chairperson, I think it is extremely relevant to discuss what happened last week and what was said this morning. It is critical for this matter to proceed. And I also have to state that I'm deeply concerned about the fact that what happened on Thursday, what was said by the public protector on Friday, and what is again now said this morning are three different versions. So somewhere, and I agree with the colleagues who have, honorable members who have said we must get that clarity. And then thirdly, Chairperson, we have stated quite clearly last Friday, based on case law, that the right to legal representation is not absolute. It is in the interest of the public that we do proceed, and that it is not only a matter of the public protector's right to be represented. We have to balance all these rights. And I think in terms of what we have done up to now, this committee has been more than generous and accommodating in terms of adjournments, postponements, etc. So I would strongly argue that we proceed immediately. And it is up to the public protector and her team that has apparently not withdrawn or withdrawn, we don't know, that they just make their plans. This committee must proceed with its work. It is our constitutional duty. Thank you.
Thank you, Honorable Lotrich. Honorable Malema.
No, thank you very much, Chairperson. I think that the question that the public protector must clarify what happened last week is a rhetorical and unnecessary, and I don't even think she must respond to that because that question was dealt with last time, and even now it has been dealt with. Those who are familiar with legal representatives will know that they come for a particular purpose. And the SC explained that before they left, that what we came for today ends here with your judgment. Because that's what we prepared for, that's what we came here to do. And because you ruled in a manner you ruled, we can't proceed with this illegal process. No one, not a single person, none whatsoever, ever uttered a word, we're withdrawing. It's you, members of the committee, who went around putting words in the mouth of the public protectors' representatives that they've withdrawn. What more do you want? You are now being told that they've not withdrawn. You still ask what happened last week. They came, they represented the public protector, and they made their points, and they were done. And they said they can't proceed because of the ruling that we made. And they were going to take up this matter outside our processes. That's what happened last week. You might not like it or whatever, but don't behave like you don't know what happened last week and ask questions of what happened last week when you know what happened last week. So, Chair, it's unnecessary, that question, and I don't think public protector must deal with it, and she dealt with it when she was giving a response. You all wanted to know what's happening, are they still here, and all of that. A clarity has been provided, they are still here. Once again, the public protector is asking for time so that she does a thorough consultation with her people. It's a right you can't take away from her. You can't. She's got a right to be represented, and that right was reaffirmed by the Constitutional Court. So you are not going to come. It's not a matter of choice. The mistake we make is this thing of every time she asks for some time so that she can consult properly and do her work, Chairperson makes unreasonable rulings of one day, one night, and things that are impractical because you've got predetermined outcome of this process. But if we're genuine and have got no agenda and predetermined outcomes, you will not even have any difficulty affording her an opportunity to do a thorough consultation. Those who are beneficiaries of apartheid, children of colonizers and apartheid dictators, they are the ones who will suggest, let's proceed with this and violate their rights, because that's how they survived all their life, violating rights of people. That's why they say it with ease, beneficiaries of apartheid, that let's proceed. We don't care. See, we know you don't care. You have never cared about rights of our people and rights of Black African women in particular. So we see that in action today, where a right of an African woman is being violated. And at the forefront of that is the beneficiaries of apartheid, who are missing those days of violating the rights of our people. You do that now with a public protector. Please, Chair, as a revolutionary and a person who fought for this constitution and the rights of our people, let it reign in your conscience that you cannot violate the right that we fought so much for the public protector, for me and you to be legally represented. Our people were hanged, our people were killed by parents of some of these people who are speaking here, without being properly represented, without being properly listened to. Today you join forces with apartheid murderers to destroy an African woman and put no value into her rights. It is unacceptable, Chair. So I think let's give Public Protector what she has asked for, and we will proceed. That document you are referring to of time frames and all of that is a living document. As in when the need arises, it will always be amended, and it will not be for the first time we don't meet the deadlines of the National Assembly. We'll always can explain that we need more time, as long as we have guaranteed and protected the rights of one of our own. Thank you, Chair.
Thank you, Honorable Malema. Honorable Mangetsi Tlabe, you will be the last one.
Thank you, Chair, and greetings to everybody on the platform and in the physical attendance. Greetings to you, Chair, and the Public Protector. Chair, let me start by saying I'm relieved. Relieved in the sense that what seemed to be a tall order when we broke last week has been resolved, in the sense that the legal team of the Public Protector is still intact. My worry, Chair, would have been starting this process all over again if she had to appoint a new legal representatives. So for me, it is a relief. And I think for this process that I might be wrong, we are about 85%, we can still make it. Two, Chair, is that what the Public Protector is presenting, like the honorable members are saying, is valid, is there. And my take, Chair, would be to say, let's look into our living documents as indicated and balance it with the notion that we don't have much time. Look at how we will cover this other time that we're missing. Because, Chair, I'm sitting here and thinking to myself that if indeed we did not schedule anything for this week, do we have a leg to stand on if we are taken on to task? Which then brings to the proposal that I want to make, that the Secretariat always meet with the Chair and look into the weeks ahead. Even if we have draft programs, it will help us a lot so that we avoid such pitfalls. And not only to do it for intentions of putting members on hold, but the reasonable program of having to offload what we need to offload, like this witness that we still have to process. So it will be my submission, Chair, that as and when we deal with this draft program, that we can change as and when. Let's always identify days that will need the legal representatives to be here so that they're also able to plan their things. But my take, Chair, is that all is not lost. We are still on track, and I'm relieved that there's no new legal teams that needs to be consulted and we start this process all over again. So on that regard, Chair, I would say, let's do it like we did last time. I remember we had strenuous week at some times that we even had to work way beyond working hours, just to balance the issue of time constraints. Thank you, Chair.
Thank you, Honorable Tlabe. We're going to try and round up. There would have been clarities sought to the PP and clarities to the Sianejo team. I just want to redirect, I'll start with Sianejo from the chairperson's point. and would conclude with the PP, whatever comments she wants to make. If there would be any follow-ups, we'll do that, but at the end, I will be making a ruling. But let me start with Tsianego. Two things. On Thursday, Tsianego team left and left the PP alone. And Tsianego knew before Thursday that were the scheduled meeting for Thursday and Friday. Tsianego left on Thursday and left the PP here. Tsianego did not come on Friday. I want you to clarify that. What's the reason for Tsianego not coming to the committee on Friday? The question of Tsianego leaving is not to be answered by the PP. The PP on Friday said she did not know why they left. I take that. I can't want to doubt. And she had done that also in writing. Tsianego has written to the chair as we flighted the letter, indicated that they have not withdrawn. They're still, the attorney is on record for the public protector. And so with that, they have not withdrawn. I think what is being asked is a simple thing to say, for Tsianego exactly what happened on Thursday and why they did not join us on Friday, knowing that there was a scheduled meeting. Today and tomorrow is a meeting that we agreed to on Friday. These are scheduled meetings. And I'll speak to that later on in terms of my ruling. But I now quickly want to just ask Tsianego, because those clarities are not the clarities to be responded to by the public protector, who was here with us on Thursday and who came back on Friday. Can I hear Mr. Theo?
On a point of order, Chair.
Yes, what is the point of order?
The point of order is that Tsianego is not accountable to this committee. It's accountable to their client, and they are not to be cross-examined or questioned by anyone. You've got an issue with the legal team of the public protector. It is the public protector who's accountable to you, and not Tsianego, and Tsianego is accountable to public protector. So don't ambush these fellows with things that they are not expected to perform here in this committee. Their job is to represent the public protector, their client, and they are responsible and accountable to their client, not to this parliament committee. The person who's accountable to this parliament committee, which is something that all of you like. Today, for convenience sake, you want to forget that you have been repeatedly saying the person who's answerable to you is public protector, not the lawyers.
Thank you, Honorable Malema. Your order is not upheld. Thank you for that. I proceed. We've already proceeded as from yesterday. There's a letter that was written to Tsianego by the chair of this committee, which they responded to. They clarified this morning. I want Tsianego to conclude responding to these issues I'm putting on the table. Mr. Theo Tsianego.
Thank you, Chair.
Sorry, Chair, no point of order, Chair.
Yes,
Chair?
what's the point of? Yes, what's the point?
Are you able to clarify why you did not agree to the point of order of Honorable Malema? Can you just explain to us why you ruled otherwise?
Thank you, Honorable Maute. I've already clarified and have ruled and declined it. Mr. Tsianego?
No, Chair, I'm not disputing that you've declined it. All I'm asking is, can you give us reasons why you declined it? I know you declined it, but I'm asking you to give the reasons why you declined it.
Now, I've given that.
Chair, I might have missed it. Can you please repeat?
I will repeat it.
Because I didn't hear you.
Thank you. I'll repeat that later. Mr. Sianeko?
But how you, Chair, no, you can't dismiss me like that.
Honorable Maute, you're not going to do a dialogue with the chairperson. I've given you an opportunity.
No, but you want to create a dialogue. I'm
Not
asking you
not
to
recognize you,
clarify,
Honorable Maute.
and you are saying you'll do it
Honorable
later.
Maute. Honorable Maute, you're going to stop what you're doing. Please. Mr. Sianeko?
Chair, I think when I was confirming the contents of our letter earlier, I indicated that I was just here to confirm that. In fact, I think what Honorable Malema has mentioned is exactly what I wanted to say to the committee. That look, firstly we wrote a letter on the 21st of October indicating that we are coming for the agenda application, and beyond that, I don't think there was anything that was supposed to be dealt with in that week on Thursday and Friday last week. So that was the letter, and we made it clear to the committee prior to the hearing on Thursday. Secondly, I don't think it is appropriate for me to be answering questions where I'm being cross-questioned about what happened on the day. And I think Honorable Zumula captured it accurately when he said the SC is the person who's better placed to respond to those questions. And especially because, and I'm not trying to divorce myself from the process or anything.
Just pause there. Just pause there before you proceed. Honorable Zungola might have said that it doesn't mean that it's entirely correct, because the Concord speaks about legal practitioners. It's not specific.
On a point of order, Chair.
I hear you.
Know that.
Yes.
On a point of order, Chairperson.
So what's the point of order, Zungola?
Chair, we in these proceedings, as you are aware from the beginning, I've never
Chairperson.
I'm recognizing you with your point of order. Just pause, Mr. Sianeko.
You asked a question to Mr. Sianeko and he's answering. You are interjecting when he's giving an answer that you perhaps do not like. So I want to raise the point of order that allow a person to finish answering a question.
That's not a
Do
point of
not
order.
interject a person when he's speaking, Chairperson.
Honorable Zungola,
That is not in order, Chairperson. Allow a person to finish. Thank you.
That's not a point of order. Please don't rise on frivolous issues. Mr. Sianeko?
Chair, I was saying, I referred you to the letter of the 21st, which I think in that letter, we made it clear that we will be attending the proceedings to deal with the agenda application. But, and I'm just saying that, Chair, just to explain why we were not expecting to proceed. But on the day, Chair, whatever happened, the SC, who's the leader of the legal team, will deal with that on when he appears on the 7th, depending on what your ruling is today. So from my side, I cannot speak on that point until the person who has been representing or who has been speaking on behalf of the legal team and the PP from our side has responded to your question.
Okay, thank you. Honorable Ngosi, I parked you. Do you want to come in before I go to the PP?
Chair, can I raise a point of clarification?
I'll note that.
Yeah, no, Chair, but the PP has not responded, but I've got an additional question then to ask the PP. What is the nature of the mandate? Is it per hearing, per issue, or is the legal team retained for the entirety of the proceedings? The process, sorry.
Okay. Thank you. The public protector.
Chairperson, must I address everything or only this one? Maybe just to clarify the Mr. Nkosi, I answered Honorable Maneli that the legal team is briefed for the entire proceedings. But I indicated to you when you asked, and I said, the letter of the 21st is very clear. They were here for that application for postponement. And I'm very much concerned, Chairperson, to proceed without my legal representation. And it's very concerning to hear Mr. Milham, the very same person who's part of the application for recusal, which was refused, including what the DA member, Ms. Lotred, is saying that the right to representation is not absolute. It means you just saying we must throw the decision of the Concord to the dustbin, in other words. I'm saying, Mr. Milham, I mean, you are even saying we are disingenuous. And the very same person whom I'm not comfortable to sit here and be subjected to you and the chairperson. I mean, today the president is dealing with the issue of GBV. It's like you are subjecting me to stay in an abusive relationship with yourselves, because I feel
On a point of order, Chair.
I can't. So I think, Chairperson, it's unfair, and I've indicated that I need to be represented.
Just a pause, Public Protector, Honorable Milam.
Chairperson, as a member of Parliament, I have every right to ask every question of any person who appears before a committee. I have not abused the Public Protector in any way, and to accuse me or yourself or to liken the questions that we have asked to GBV is absolutely untenable. And we can't proceed in that manner, Chair.
Person, this is not a point of order.
The purpose, we're here to find out the facts, and we are here to make a determination and a recommendation to the
That is
National
not a point of order, Chair.
That's not a point of order.
Sorry, I believe I have the floor, Chair.
No, don't say so. We're talking to Chair. We're not talking to you.
This is not a point of order, Chair.
Chair, in terms of the rules of Parliament, it is unparliamentary to cast aspersions or to malign any member of Parliament. And that is exactly what the Public Protector is doing by likening my presence here and my questions to witnesses. I haven't put any questions to her directly, except for those in writing, to being likened to gender-based violence. And I take the strongest exception to that, Chair.
Thank you, Honorable Milam. PP, I'm going to ask you to restrain from that kind of an approach. It included me too, as a chair. I didn't call a point of order. I think it borders on being inappropriate to say you feel that we are abusing you. So I'd like you to proceed and respond to the issues that have been put.
I said, I feel, I'm giving an example. Saying to a woman who's abused, just stay in that relationship. I feel, I'm saying I feel like that. I'm not saying you are doing that. That's how I feel. And I'm saying to you, he is saying I'm disingenuous. So I wonder whether that is fine for a member of parliament to also say that in these proceedings. So it's nothing. And I wonder whether you will request him to withdraw that. But then secondly, I am saying, I feel like being a woman who's sitting in that environment and being told, just sit there and not do anything. Hence, I said to you on Friday, Chairperson, you think you are fine, I can proceed under you. I feel I can't proceed under you. Hence, I said to you, then you need a third person, that third empire, who would say, but then is that the proper environment to proceed? I'm just saying that, Chairperson.
Just to assist you, that issue that you're raising is related to the recusal application. We're not there. We're not asking you to respond to that. We've passed that stage. We're asking you to respond to specific issues as to what happened on Thursday, that your item is on record and so on. That matter was placed on record firmly here by your legal representative. Please proceed.
I think, Chairperson, I've already addressed everything in the letter. I've dealt with all the questions which have been asked, and it's up to you what you decide, whether we proceed with without the legal representation. But I think everything is addressed in my letter and what needs to happen. And I've indicated that the legal team is available on the 7th of November.
Are you done, PP?
Yes.
Thank you. Honorable Walangwala, before I go to Advocate Bauer.
Thank you, Chair. No, it's just a follow-up question. It was the public protector says the attorneys and the councils appeared in respect of the adjournment application on Thursday. They left because they were done on their instructions on the day in question. But what is not clarified more is that Friday we were not dealing with the adjournment application, but they were not in attendance. Hence, we had to postpone the sitting. So what was the issue on Friday? Thank you.
Okay, thank you. Advocate Bauer.
Chair, this all started with a postponement application to have the matters postponed till the 7th of November. That was refused. Advocate Mpofu on Thursday indicated that his mandate after that application was refused, that his mandate as the legal team was to do this application. And then he said, what that means is that we are not able to take part in any of the further, he called it illegal activities, which would go beyond the application for the adjournment. He went as far as to say, I'm afraid as far as the legal team is concerned, that will be as far as we can take it. Good luck. Maybe we'll see you again, maybe not. Now, what has not come out of this entire exchange is that Mr. Senego, who is the attorney of record, has indicated that he gave counsel a mandate to move only the adjournment application. Did he get an instruction from the PP to do that? First issue that's not come out today. And the second thing I'd like to clarify is that the first Constitutional Court directions for the proceedings on the 24th of November came out on the 3rd of October. It combined for hearing on the 24th of November, both the applications that had been brought by the DA as well as the president set down for hearing on the 24th of November with filing dates. The second application came out, the second set of directions came out on the 12th of October. It combined any appeals and cross appeals to be heard simultaneously with that. The third set of directions, which came out on Friday, did only one thing. The PP had brought an application to implement in the High Court and an application for leave to appeal in the High Court, and it simultaneously brought an application for leave to the Concord. The Concord consolidated that impeachment application with the application that had already been pending. And that's what the series of directions of the Constitutional Court shows. There is nothing untoward about that. It wasn't the basis for the postponement application last week, knowing that the applications were pending before the Constitutional Court. That was not the reason why the postponement was being sought. I just sought to clarify that.
Thank you. Thank you for the clarity. I want to go towards the break. Peggy Zwengosi, you have your hand up.
Yeah, Chair, are you going to make a ruling now or after?
Yes, good day. You're speaking to General Bantu Olomis, reference KE.
And then?
Can you mute him? Chair, I'm just asking if you are going to make a ruling after or now.
If you want to say something, I'll give you that because
okay,
I
Chair.
will make a
I
ruling. We are going to immediately after hearing from you, and I see another hand now. We're going to take a break and I'll make a ruling when we come back from break.
Okay, thank you, Chair.
What's your reference, Honorable Boss?
I would like you to. Yeah, Chair, I would like you in making your ruling, I would like you to consider the following. Firstly, that the PPSA and its incumbent are accountable to Parliament and only to Parliament for the performance of their work through and through. And in this instance, in this type of hearings, the PP is accountable to Parliament. Secondly, Chair, I had indicated earlier in earlier discussions, I can't remember when, that as a committee, we must determine that we do have recourse ourselves, either to the National Assembly through its leadership or the courts of the country. And I would have made a suggestion earlier that in the event that we see that there are obstacles placed in this process, shouldn't we ourselves on our own through Parliament approach the courts or the declarator to determine, to ensure that this process is done within reasonable time? We are not without recourse, Chairperson, and that's my issue, that we can do anything. I can tell you and assure you that next time we meet, there will be other obstacles that are placed. Let us look at alternatives to ensure that this process continues. Thank you.
Thank you, Mr. Nkosi.
Here's something interesting. December flights. Some of South Africa's most popular routes, Joburg, Cape Town, and Durban, are now.
I was going to suggest as a way forward, but after hearing what Honorable Nkosi has said, I do agree. I think last time I impressed upon the fact that we should look into the possibility of exploring what legal options we have, because I suspect that we are going to encounter more hurdles in terms of this inquiry proceeding. But I was going to suggest as a way forward that we proceed with the inquiry today. We hear evidence from Mr. van der Merwe. Chair, by proceeding with the inquiry today, we will not be denying the public protector her right to legal representation. We've not, in any way tried to deny her of that right. If anything, it's the legal team that walked out on the day that denied her her right to be represented. So I suggest that we carry on with the proceedings. As you stated as well, her legal team was informed that should the adjournment application not succeed before the committee, they will be required to proceed. And we are still not sure what happened or last week, why her team walked out. And we're not getting answers at this point. So I suggest we proceed, Chair. Time is not on our side. The cost implications of delaying this inquiry further are also, increasing day by day as we keep on putting off proceeding with this inquiry. Thank you very much, Chairperson.
Thank you, Honorable Gonda. Honorable members.
Chairperson.
Public Protector.
I want to just put on record that my legal team is not on retainer like the evidence leaders. And to indicate that they received this and this and this is not to say they are just sitting and only doing this kind of work. And secondly, for them to prepare on the one side and on the other side to also comply to all those necessary time frames. And as I'm indicating that on the 28th on Friday, they received more than 2,000 pages of pages from the DA. And they have to respond to that and comply to timeframes. And secondly, the fact that I'm here accounting and indicating what is the best solution and being given few days. And I said it as well on Friday. It's a matter of communicating and agreeing. It's so unfortunate that that is treated as if it's waste of resources. But now there is a proposal to go to court to waste resources to get legal teams again to prepare documents which we would want to also defend. So I think when you consider all these things, it's just a question of few days, and it's just a question of being seen to be fair, Chairperson. That's all I'm just saying to you when you consider the matter.
Thank you, PP.
Chair.
Chair,
I've noted your hand, Honorable Malema.
Chair, can I?
Hold on, please. I see people don't want us to break for tea. Honorable Malema.
Chair, I think Public Protector in a way asked you to ask Honorable, the husband of Honorable Mazoni, to withdraw that disingenuous thing. If you want us to use polite language, please apply it even if it affects white honorable members. Your ruthlessness must not only be applied on us Africans. Please, that utterance that this submission is disingenuous, is unacceptable, and please ask that honorable husband to withdraw.
Thank you, Honorable Malema. Maybe let me make a ruling on that. Disingenuous is not unparliamentary. They cannot ask a member to withdraw that. We use that in their house, we use that in others. It's not unparliamentary. I can't be applied. There will be no rule that I will rely on to do that.
You are disingenuous
Harsh
now.
words, but that's not unparliamentary.
Even you are disingenuous.
Aibo, that. Thank you, Honorable Malema. Advocate Bauer.
Maybe just as a point of clarification or correction, the evident leaders are not on a retainer. We do our work as we would on billing rates as advocates, and we no work, no pay.
All right. Thank you, Honorable Bauer.
Chair, can I get clarity, please?
On what now?
This evidence leader, why is she speaking if there's no evidence being led? Why is she speaking in this committee? Because she must only speak when she's leading evidence. What is this? Chair, why is the evidence leader speaking when there's no any evidence led? Why? Because if there is any matter that seeks clarity, like the one she says she's clarifying, you can clarify that. Under which rule is she participating fully as if she's a member of this committee? When she's got a specific role to play. Please, man.
Thank you, Honorable Malema. I took some time on Friday as we were closing the meeting, and I touched on two areas. Unfortunately, you could not be with us. I touched on two areas where I gave a bit of detail. One had to do with the issue of the support staff, that I explained their role as anchoring and supporting this committee, be they content advisors, legal advisors, and entire secretariat. I went at length in explaining what their role is and the fact that they are part of the committee. I proceeded in explaining that unlike other portfolio committees that we have, in our terms of reference, we designed what we called a hybrid process, because this is supposed to be, instead of it just being a member-led kind of an inquiry, we agreed in terms of those terms of reference to create that hybrid and get external expertise. And that we then designed it as the evidence leaders, and that their role is to assist the committee. It's not just limited to cross-examination, or it's not just limited to leading evidence. They have to participate to ensure that every step of the way, this committee is empowered and issues are enlightened and so on. I'm not going to necessarily repeat, but I'm taking this opportunity to say I did address the matter on Friday. As we concluded our meeting, I do recognize that you would not have been with us in that meeting, because you're raising this concern. Thank you, Honorable Malema. Members, we're now going to take a break and be back at 12. Thank you.
Recording stopped.
Welcome back, colleagues. After that tea break, as indicated, it's now just 12 o'clock. We are resuming. Quite clearly, Friday, the committee concluded in its deliberations as part of the decisions it has taken that today we're going to resume, and central to that resumption was the issue of putting on the stand the last witness, Mr. Niels van der Merwe, to start leading the evidence. As you will see in the affidavit, it's quite a lengthy affidavit, and it's planned for today and tomorrow. And as I indicated earlier on, the second part of us on Friday agreeing to resume today and tomorrow was that we're going to get a feedback also from the public protector, which she has given. It is that feedback that would have taken from 10 o'clock up until now. Today we have been given a half a day owing to the 3-line whip that is happening, that our day must end at 1 o'clock. We are going to do that. Members have had a lot of deliberations. What is clear, and this would have been the first question asked, that there are quite a number of questions that are unanswered as we sit here, that we'll continue having to find answers on. And I would have even given an opportunity for further clarities on those, including specifically to the attorneys on record. I've not received answers to those questions. We'll pursue getting answers to those even beyond this meeting. And having given everybody time to place their matters on record, to make their contributions and suggestions, it's clear, members, that the resolution we took on Friday must be proceeded with. And for that, I want to indicate that the attorneys on record been with us since 10 o'clock. They're still here. Mr. Sianejo, you are not excused or permitted to leave. We will start now with the next proceedings and conclude at 1 o'clock exactly. And that next proceedings is to allow the evidence leaders, starting with Ms. Fatima Ibrahim, to introduce this next and the last witness, which is Mr. Niels van der Merwe, who will lead evidence from now until 1 o'clock exactly. And for that, and tomorrow we'll continue with the same witness the entire day. There is no cross-examination expected today or tomorrow. There will not be a cross-examination. The focus will be taking time leading the evidence of this witness. The public protector placed on record that on the 4th of November, there's an expectation for them to put together court papers, heads of argument. That date is on Saturday. So if we conclude tomorrow, she is still given time and her legal team to be able to do that. And that heads of argument is in preparation for the 24th of November. As she would have highlighted the aggregate issues that will be attended to when we listen to her. It is going to require that after today, after 1 o'clock, we're going to relook into terms of the program. She would have indicated from the 7th, that availability, we've got to look into even before the 24th, how many days we're going to give for those parties that are involved to prepare for that date of the 24th. So that speaks to the program already, something that as a chair and the secretariat, I'm going to attend to. I'm hoping that we can present that tomorrow to you to say, in the light of what we've had, from the 7th, availability was indicated, because after tomorrow, it is going to be, even if we take a break of few days or a week, it's going to be a time when we then invite the public protector, firstly to do the cross-examination of those two witnesses, but also the entire witness list that she has, that it would be led in that way. So there will be time, therefore, to allow for preparations for that. And so, honorable members and colleagues, that is the ruling that I am now making. And I'm going to ask Ms. Fatima Ibrahim to do the preliminaries and introduce the witness.
Thank you, Chairperson. Good afternoon, Mr. van der Merwe. Can you hear me?
Good afternoon, Advocate. Yes. Am I audible?
Yes, you are. Thank you. I'm now going to administer your oath. Mr. van der Merwe, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Mr. van der Merwe, please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or a period of imprisonment not exceeding 2 years. You'll now be required to take an oath or to affirm that the evidence you're about to give is truthful. You may choose either the oath or affirmation. What is your preference?
I'll take the oath.
If I can please ask that you raise your right hand and repeat after me. I swear that the evidence I shall give.
I swear that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you, Mr. van der Merwe. Chair, the witness is now duly sworn in.
Thank you, Mr. van der Merwe, for availing yourself. I am aware that you'd have been ready all the days that we were dealing with our issues here that we're processing, because we have to have a very credible and a fair process. I now invite Advocate Bauer to lead the evidence.
Excuse me, Chairperson.
Pause, Advocate Bauer.
Sorry.
Public Protector.
Excuse me. I want to check, can I be excused?
No.
Because I not participate, I don't have my legal representation, so I'll just sit here, it's fine.
Please proceed.
Mr. Van der Merwe, I think we have some problem on the screen. Good day, Mr. Van der Merwe. You are currently the Senior Manager, Legal Services in the Office of the Public Protector, correct?
Good afternoon, Advocate. Good afternoon to you, Chair, honorable members, and the Public Protector. That is correct, Chair.
Right. You have occupied that position since 1 August 2020, following a recruitment process that had commenced in May 2022, correct?
That's correct, yes.
Now, you commenced employment. So
You have to go ahead. We're operating under that.
Mr. Van der Merwe, you set out your history of your employment in
We'll
paragraph.
try and fix it as you go along.
Yeah. You set out your history of your employment in your initial affidavit at page 4060 of the record in paragraph 2. And I'm just going to quickly take the committee through it so that they can have some background, and then you can confirm it once I've done that. You started working at the PP's office in January 1997 as a senior investigator. In 2010, you were appointed as a manager in knowledge management and research to provide research support at various levels in the Public Protector's office, including making submissions to Parliament and providing research support in the office. And you did so to the executive levels, to the Public Protector, the Deputy Public Protector, the CEO, as well as the investigative components. And you provide specific input and research, as well as updates on judgments handed down and implications thereof. Your input was hardly ever sought in respect of the merits of litigation matters and to strategic decisions. You then point out that as knowledge manager, you're responsible for statutory functions under PIA and under the Promotion of Access to Information Act and the Protection of Personal Information Act. And you draft submissions for the Internal Policy Review Committee. You currently sit on the Quality Assurance Committee, as well as the structure now known as Full Bench. And you've been involved in obtaining the electronic case management system for the PPSA, as well as being involved in information technology. You then point out that you're also involved in data relating to a number of cases finalized and backlogs, reviews of reports and judgments, and orders and legal fees actually incurred in each year in your capacity as Senior Manager, Legal Services. You've had a look at that. And we're going to, during the course of your evidence, go to that. And we point out that these amounts would not include accruals, as would be the case with the annual financial statements. Is there anything you'd like to add to that?
No, that is correct. Thank you, Chair.
Because of our time constraints today, for the committee's purposes, Mr. Van der Merwe's evidence is going to span evidence that we heard right at the beginning of the hearings relating to the CX APSA matter, because he had some involvement in that. His evidence will also deal with the question of statistics and the number of cases reported in the office from the annual reports, and he will deal with items 11.1 and 11.3 in the course of his evidence. Because of our time constraints today, I don't want to touch on the APSA matter and the statistics because we might just lose each other in that. I'll rather start with that fresh tomorrow. So I'm going to start off by taking him to his supplementary affidavit firstly. And that relates to documents, and that's at 418545 of the bundle. And it relates to documents, invoices, and emails, in the main of which, Mr. Van der Merwe, you didn't have personal knowledge, but it came to be with you in your capacity as Senior Manager, correct? Legal Services.
That's correct. Yes, I'm now the custodian of these records and documents.
And so it's through you that this evidence is being led to facilitate it to the committee, right?
That's correct. That's correct.
You'll have to raise your voice, speak closer to the mic so that we hear every word you say and every response you make.
Thank you, Chair. That's correct, Chair.
And you had no reason to doubt the veracity or the accuracy of the contents of these documents, and they emanated from the PPSA Mimecast system. Can you just tell the committee what's the Mimecast system?
Thank you, Chair. The Mimecast system is our cloud security system that protects and stores our emails, data, and web information, and protects the critical communications, people, and data of the Public Protector South Africa.
And you explain that it came about after you were requested by the evidence leaders to provide you with documentation arising from an invoice which is to be found at bundle F, item number 145, page 2990.
That's correct, yes.
Right, and that is an invoice from Sienego dated 20th December 2019. And it was statement 2997. Bundle F 2997. Yeah, we've had it before. 2997 is
Yes.
the payment. Your assistance was sought in locating an invoice dated 27th August 2019, which was identified as media publications. Now move back up, Seppo. It's one in the yellow highlights. In the amount of 416,726. Correct?
That's correct, yes. We made inquiries with our finance section as well as the manager legal services, Mr. Sitole, to try and trace this invoice.
And he was not able to provide you with a copy thereof, correct?
That's correct, yes. He said he will check his emails and later on said that he will request a duplicate or a copy of the invoice from the attorneys. The statement is from Messrs. Sienego Incorporated.
Right, and you then explained that this document that's now on screen was found among invoices and statements that was provided to the evidence leaders in 13 bundles of invoices covering the period 2017 to 2022 by the finance department. You say that in paragraph 3 of your affidavit, and it also included invoices that was provided by Mr. Sitole.
That's correct, yes. Our finance section went through all the legal services invoices, and we provided hard copies as well as electronic copies to the committee.
Right. Now, in paragraph 3 near the end, in the last 3 lines, the finance department indicated to you that they would have to search for this invoice because at the time, it was all handed in hard copy, but the records show that it was not paid. Correct?
That's correct, yes. There was a query from the CEO at the time, which led to its withdrawal.
Right. And Mr. Sitole had received this invoice and he confirmed that to the committee when he gave evidence. Right?
That's correct.
And in paragraph 4, you explain that at the time, the PPSA was on a manual system and invoice and documentation to obtain the approval of payments was not submitted electronically, and it would have required a search to find that invoice. And Mr. Satoli had indicated that he would search and he would request it from Senego. Did he revert to you in respect thereof?
No, thus far I have not received any indication from him that he has been able to trace and find the invoice.
But we have found the invoice. If I go to Annex just CM1 to your affidavit at page 418549.
That's correct, yes. The invoice was traced in the bundle of invoices that we supplied.
Right. And then if you, I'm just giving SIPO an opportunity to catch up. It's the invoice that's in the amount reflected on the statement of 416,726.40. All right.
That's correct.
Unfortunately, I can't share whispering.
So
Yeah. Okay.
it's bundle 24A.2. It was redacted and that's why I did that. Sorry, my apologies, Chair. If you go down at 4185.49, one sees the invoice. One sees it in bundle D, item 24 in Van der Merwe. You go to supplementary affidavit and it's 24A.2. Got it? This is the invoice. If you scroll down to see the invoice, the contents of the invoice, it doesn't have a heading. And the first entry says, travel to Pretoria, met with client, Mr. Ngubeni, Professor Siepi, and Ms. Kimala to discuss how to counter the onslaught on the media on the public protector, and Senego charged to do that with traveling costs. Received documents from client, perusal and consideration, various telephone calls, and then a second consultation of traveling. And then if you go to a disbursement, you see an entry that says Ngubeni executive consultant's fee in the amount of 390,000. Right.
That's correct, yes.
Correct?
That's correct.
If we go to the next document in the bundle, which is at 418551. Right. We see the invoice for Ngubeni Executive Consultants. We see an account into which presumably payment must be made in the name of Abel Ngubeni, dated 1st August 2019. And if you go further down, you see Paul M. Ngubeni, Public Protector Project, invoice April 2019 / July 31st, 2019. Correct?
That's correct, yes.
Right. And if you go down further in this invoice, you will see various entries dealing with a number of matters. And I'm going to take you through the documents which relate to these matters. And as we go along, we will link it to an entry in this document. So that's just to give the committee an idea of where we're going. I want to take you, Shipa will leave this open on the side. We're going to go to page 3143 in bundle F. And for the most part, all the documents we're going to be referring to is item 161 bundle F. Right, and we start with 3143. at the bottom. Most of the time, the emails go from the earliest to the latest. And we see at the bottom on the 14th of February, 18th of February, 2019 is an email from khalle.consultancy at, well, I'm sorry, let's not go there. We see an email from Kim Halle to the name that's taken out in the version put up, it's taken out because it's an email address, but it's the email of Sipho Siepi and one Ephraim Kabinda. Who's Ephraim Kabinda?
Ephraim, Mr. Kabinda is the PA, personal assistant to the public protector.
Right. So now we know Ms. Halle contacts the PA and says, "Dear Ephraim, I hope you're well. May the year ahead bring you great fulfillment." And I don't intend for committee's purposes to read out all of it. I'm just going to highlight certain aspects of communications as I go through. And it says, "I would like to set up a follow-up meeting with the public protector on the discussions we had in late 2018 on strategic consultancy services." In the last couple of lines, it says, "Further to our meeting last year and the submission of a detailed proposal, as the public protector requested, we have extended our scope and network beyond communication services to include unique strategic offerings, thought leadership, research, and investigative capacity. In this regard, a registered entity is in place." Right?
That's correct, yes.
If we go up to the second email, we see Mr. Kabinda sends this email to the public protector as well as to CCs in Sibusisi Niyembi. We know he was the chief of staff at the time, correct?
That's correct, yes.
Right. And the PA seeks to confirm the contents of the email. And if we go up to the top of the document, we see that the public protector responds and says, "Yes, we had an engagement and I said they should arrange another meeting." And she goes further and she says, "CEO and CFO, can you engage the sender of this email on my behalf, advise on how we can use the services to augment marketing of PPSA and its impact?" CEO forwarded the proposal and I had hoped you will follow up and advise on how we can source the services.
That's correct, yes.
Next page. We know from the next page, which is 3144, the services which we told about is with, don't go up at 3144. What Ms. Halle had offered was Professor Siepi and I will present this amplified service offering to the public protector and the team, which we believe will strongly augment our original proposal and value proposal to the team. And there's a plan to meet in March. We then go to 3151. And we see Mr. Sianejo provides what he identifies as Prof and Kim with his contact details. And if you go to 3152, you see there, Mr. van der Merwe, that Ms. Halle responds and says, "Good evening, Theo. Lovely to meet you today and look forward to working alongside you."
That's correct, yes.
Right. So she acknowledges that she's going to be working alongside him. You see that?
Yes, Mr. Sianejo and Professor Siepe.
Right. If you go to 3153, you will see Professor Siepi says, "Great, got it." He also is provided with the contact details. If you go to 3154, you see that Ms. Haller then provides what is a PP strategic communication service document. And she sends it to dear Theo and Opa. Who is Opa, Mr. van der Merwe?
Opa was until yesterday the public protector's spokesperson, Mr. Segalwe. He was in communications at the time.
And he was during this period the spokesperson for the public protector.
That's correct, yes.
Right. So if you go to 3155, right? We see the proposal that Ms. Haller makes, and I just want to highlight certain aspects of it. And it says, further to yesterday's engagement on the pressing need to counter the total and unwarranted onslaught by media on the person and office of the public protector, we please find below a proposal with reference to strategic communication services for the period Friday 7 June to Friday 4 July. See that, Mr. van der Merwe?
That's correct, yes.
And so there is a proposal for a 4-week period to reshape the agenda and change the negative perceptual landscape created by negative publicity and propaganda. And
that's correct.
Yeah. This will be done principally through reasserting the primary constitutional mandate of the office and correcting faulty misperceptions of the office and the person of the public protector orchestrated by mainstream media and interests and the residents in the public arena.
Yes, that's correct.
And then what they call our communication posture and program is informed by the following, and I'm just going to highlight a few of them. In 3, it says assisting the office to purposefully navigate all platforms and media opportunities. Did the office have a communications department at that time?
Yes, they did and still do, which is tasked with dealing with media responsibilities and communication functions of the office.
Right. And how many people's employed in that department?
I think they will, it's it's about 4 or 5 people, including a manager. And there was a senior manager at the time as well.
Right. So then, in paragraph 4, it says there's a need for all communication to be strategically aligned and integrated. This will require the underpin of a pre-agreed set of messaging and the tonal fabric of communication. It will require a full concert and accord between the communication service providers, the office spokesperson, and the legal advisors. Protocols and procedures on communication development and distribution will need to be agreed upon the commencement of the project agreement. Full adherence to factual communication and fact-checking. And in 6, it says the need for fullest preparation and rehearsal of any public appearances and announcements by the public protector herself or any representative of the office to guarantee best delivery of message and exemplary response to media questions.
That's correct.
To your recollection, was this proposal ever put before the MANCO?
No, we checked both against the operational plan of communication section as well as the MANCO minutes around the time. And there was no report back or decision register or anything covering such a project or such a strategy in the communication section at the time, formally reporting to the CEO or MANCO.
Right. It then goes on to say, with immediate effect, a rapid deployment force made up of the public protector spokesperson, the communication and legal advisors, and senior executives from the office will need to be ever ready and ever present operationally and strategically to respond to any crisis that may arise, as well as to develop proactive communication initiatives. And it further then talks about dealing with it to counter an immediate and intensified media onslaught over a 4-week period. And Ms. Haller says, as we activate the communication program over the next 4 weeks, wherein the next 10 to 14 days will be extremely intense, the following factors must be borne in mind. 1, what we're seeing is the perfecting of the media strategy that was used against Jacob Zuma. 2, opposition to the PP is akin to a spiritual war. She can do nothing that could be considered right. This will require a very sophisticated reincarnation positioning exercise. 3, it talks about an echo chamber to be unleashed on the office and a person heavily resourced. 4, it talks about detractors wearing her down, identifying the Vrede matter as a case in point. 5, she's faced with the challenge of having to contend with judges that seem beholden to a political party and elite interest. And 6, that the resource will always create the highest level of noise. They then put forward a certain recommendation. And then they say in the next page that over a period, they will write and publish a series of articles and social media communications which correct misperceptions, as well as offering a convincing portraiture of the good works of the office.
That's correct, yes.
Are you aware of this senior management being alive or participating in any of these series of articles? Were you aware of it?
Yes, around that time during our Manco, and I'm not sure if it was at Exco as well, there was a call for what they called good news stories or good stories about the office, that the investigative branches were requested to provide 2 communications.
And so they then detail on page 3 what they're going to providing, messaging for all communications. Now you've gone, no, are we still on that page? Go back. Number 1, right? Messaging for all communications. This is presumably leading back on different social media platforms. Is that how one should understand it? Communication?
Yes, that's correct. Yes, with external stakeholders mostly.
Advisory notes on dealing with emerging negative publicity and propaganda. 3, educational videos and fact sheets. 4, strategic guidance. 5, assistance with social media drives. 6, skill development. And then it says key thought pieces will focus among others on judicial prejudice, the lynch mob mentality of the media, the judiciary and civil society in the deliberate unsteadying of the PP, the unpacking of the Pravin Gordhan saga, the undone matter of the rogue unit and the CX, and profiling the People's Public Protector. And it says the first article will be ready by 10th June, and they will bill for strategic services from 7 June to 4 July in the amount of 120,000. And on the next page, they set out the key skill sets and experiences. Mr. van der Merwe, if one reads this, is either Professor Siepi or Ms. Haller does not reflect any legal qualifications, correct?
Yeah, no legal skills, competencies, or qualifications reflected here in the profiles. Chair.
Right. So if you go down to 3160, go to the bottom, we have to read the emails from the bottom up to follow a chain. So we see the email on the 5th of June where Ms. Haller attaches the proposal on strategic communication services. And then if we go up, we see on the 6th of June, the proposal is given to Mr. Nyembi as the Chief of Staff. And the members will recall Mr. Mashlangu, who was the then acting CEO, is provided with a copy of the proposal. And if Mr. Mashlangu was acting CEO at that
Was the
stage.
no, he was the CEO.
Was he the CEO? Okay, my apologies,
Yes,
Mr.
Mr.
Van
Mashlangu was.
Okay, then if you go further up, there's a, no, go down on top of the page. From the public protector, it says COS, and are we correct in understanding COS to be short for Chief of Staff?
Chief of Staff, that's correct, yes.
It says the public protector writes COS, this should include Advocate Ngubeni, and please request cost breakdown, not total, so all can be accommodated. Ask Theo to advise cost per article, per interview arranged, etc.
That's correct, yes.
If you see the timing, it's sent about 5 minutes after having received the proposal. If you go
That's
to
correct, yes.
3163, at the bottom of the page, bottom of the page of 3163, that's the top. Go down. Right. Mr. Nyembi sends an email to Mr. Senego. PP suggested that this should include Advocate Ngubeni, and they should provide a cost breakdown, cost per article, per interview arranged, etc., not total, so all can be accommodated. Kindly advise what your view is of the above. You see that, Mr. Van der Merwe?
Yes, that's correct.
Mr. Van der Merwe, are you acquainted with Mr. Ngubeni at all?
No, not personally. I just knew from the discussions in the office that he was involved in some of the projects in the office. A panel that was apparently advising the public protector on the side, and as far as I know, he was not a legal practitioner that was on our panel of attorneys or one of our service providers.
Did the name of Ngubeni ever come up in any interactions between you and the public protector?
No, not in any interactions with the public protector, no.
With anybody else?
Yes, well, as I said, colleagues, and we were discussing about the fact that one of my colleagues mentioned we were aware of the fact that there was a so-called panel of advisors that were assisting the public protect external people that were not contracted per se or employed by the office as advisors or assistants to the public protector.
Okay. Can we go back to 3163? All right. If you go to the top of 3163, you see that Mr. Nyembi then has a phone call with Mr. Senego to discuss the proposal. And if you go to 3165, go to the top. It says there, Mr. Senego then writes, morning, Mr. Nyembi, Kim will speak to the prof and revert with an itemized fee proposal and see if they can include Mr. Ngubeni. I will revert as soon as I hear from her. That accords with what the instruction was from the PP to them, correct? From an earlier email.
Yes, that's correct. To do a breakdown of the fees, not to just quote a total amount of 120,000, and then also to include Mr. Ngubeni.
Right. Can we go to page 3205? At the bottom of the page. Just to jump down. We see that on the 13th of June, we get an email from Ms. Haller that says, "Dear Theo," and she provides it to Mr. Sienego. As requested, please find a breakdown of our consultancy costs for strategic communication services for the period 7 June to 4 July. Paul will send his costs under separate cover. That's presumably Paul and Ngubeni, correct? Well,
Yes, Mr. Ngubeni.
the professor and I would like to arrange a meeting with the team at your soonest convenience to concretize next steps. In fact, if you go up on that email list, the people to whom the email is sent, we see Mr. Ngubeni is included in the email list as Paul Ngubeni.
That's correct, yes.
And if you go up to the top, it says, "Dear Kim, thank you for the mail and breakdown. We'll see guidance from the PP's office and revert." And if you go to page 3203, we see this breakdown. There's an explaining on the first page, and I'll take you to the last paragraph of that page. It says, stop the last paragraph of the previous page. Go up to the bottom of the previous page. You've skipped the page. Go up. Oh no, sorry, go down. The last paragraph of that page. It says at the bottom, since the 7 June 2019, we have provided advisory notes and direction, crafted high impact and highly publicized articles, radio interviews, and social media postings. And on the next page, the costing is broken down as per the PP's request of an hourly rate at 1850, services at 120, and the rate is below the recommended government consultancy rate, signaling our commitment to this project. And we see an estimated hours is put out for reading, article prep, interview setup, social media activation, advisory notes, and correspondence meetings. And then
that's great.
At the end of this period, we will do a reconciliation of the hours worked and a measure impact. Are they included in the database of consultants at the PP's office?
No, we checked with supply chain and we could not find any either persons or consultancies in the name of Professor Siepe, Kim Haller, Mr. Ngubeni, or the entity in which some of the invoices were made out. So they were not consultancy service providers or on the database of consultancy service providers for the PPSA.
And then if you see at 3206, is an email which Mr. Sienego writes to Mr. Niembi and the communication spokesperson, Mr. Sagalwe. And he says, "Good evening, gentlemen. I hope you are well. I had a telephone conversation with Professor Siepe today. He suggested that we meet sometime next week to jointly map the way forward. We also need to finalize the fees with Kim. I hope you read the emails he sent yesterday. No need for the PP to attend the meeting. Kindly advise which suits you." Okay.
That's correct, yes.
Then if we go to 3166. Right. This is an email from Mr. Ngubeni and it refers to a advisory note. Correct?
That's correct, yes.
Right. Now, just before we deal with the check, could you go back to 24 capital A2, which was the invoice we had earlier? All right. And look at the entry for 11th and 12th June. We see drafted legal opinion on controversy on PP social media and section 7(9) notices is the entry by 11th and 12th June. Do you see that, Mr. Van der Merwe?
Yes, that's correct.
Right, now we go back to the email at page 3166. That is the same as the heading in the subject line.
Controversy on PP social media and section 7(9) notices. Yes, that's correct.
Right. And so essentially, Mr. Nkubeni is providing them with an advisory attached regarding section 7(9) notices and the public protector's use of social media in connection therewith. I concluded that both the use of social media platform and the public announcement of section 7(9) notices regarding Gordon were unlawful and proper. Were lawful and proper, sorry.
Yes, that's what it says.
So if you go to 3207, you see an email from the public protector that thanks Advocate Nkubeni and says legal and cause, please advise.
That's correct. For the benefit of the committee, can I explain what the section 7(9) notice is, or will we get to that?
Well, we'll get to it in a moment. If you go to page 3167. This is the advisory that is drafted, right? And maybe Advocate Van der Merwe, it's been a while since we've dealt with it. Could you just very briefly just deal with the section 7(9) notice?
Yes, in terms of the Public Protector Act, when an investigation is concluded and before the Public Protector can, and there's a possibility of an adverse finding or person who's implicated, then section 7(9) of the Public Protector Act requires the Public Protector to notify the person implicated or whose interest is affected by the outcome of the investigation, and to be given an opportunity to respond to the summary of the investigation, and the adverse findings are provided in a notice, what we call, it's a confidential notice, and it's issued to the specific persons, and then they are provided with an opportunity to respond, whereafter the final decision and finding and remedial action is taken in terms of section 182, 1A and C of and B of the Public Protector Act, of the Constitution, sorry.
If you go back to page 3167 on the advisory, we see from this that it arose because the Public Protector issued the section 7(9) notice to Minister Gordon on a social media platform, and the erstwhile Public Protector Advocate Madansala then responded criticizing this, correct?
That's correct, yes, because it is, as I said, a confidential notice. We've had various leaks, and it's one of the issues we take serious note of, to treat it confidentially.
So I don't want to take you through the entire note, but there's 2 or 3 things I want to highlight to you at the bottom of page 3168, the last paragraph, because it touches on something that arose a few months ago in this committee. It goes further down. It starts with the sentence, the Public Protector's decision to issue provisional reports serves the salutary purpose of providing an adequate notice to the affected party. And then it says, at a minimum, due process means that the citizen who will be affected by a public protector's decision must be given advance notice of what the public protector is investigating and how the person is being implicated in the matter being investigated, and how implication may be to the detriment of that person, or that an adverse finding pertaining to that person may result.
Yes, that's exactly in accordance with the provisions of the Act.
You would agree that that is a salutary approach and it's in accordance with what you should be doing, correct?
That's correct, yes.
Now, I raise this, Advocate van der Merwe, Mr. van der Merwe, because when Mr. van Lochenberg was giving evidence, it was put to him that the position is that he was not the primary target of the investigation, and hence he didn't need to get such a notice. What are your comments in respect of that?
No, that's in fact one of the principles that the courts have been elaborating on, is that it does not, there's no such thing as a primary target of the investigation. Any person whose interests are affected or may be adversely affected by the outcome of the investigation is, in terms of the audi alteram partem rule, here the other side, entitled to be informed not only of the finding but also of remedial action. And a number of the public protector's reports have actually been set aside based on non-compliance with this provision.
Okay. And in fact, on page 3169, at the top of the document provided by Advocate Nkubeni, we're not going to read that section, but he essentially articulates that very basic rule of natural justice, correct?
That's correct, but although the PP refers to advocate, to Mr. Nkubeni as advocate, I think we've confirmed from our side that we couldn't find that he was indeed an advocate.
Right. And if we then turn page 31. 3174 at the bottom. The advice given in the very last paragraph. It says, similarly, there is currently no jurisprudence on the conflict between the right to dignity and the public protector's duty to fulfill a mandate in terms of sections 181 and 182 of the Constitution. More importantly, that when it comes to remedies, it would be nothing short of dereliction of duty for the public protector to allow individuals who have been implicated in serious acts of maladministration to publicly malign her, call her incompetent, and vilify her as a political tool for others without an effective response from her. She may be compelled at times to refer to other investigations in order to refute the accusations that she has ulterior motives or that she has targeted a prominent politician for political reasons. Gordon's public utterances and political antics invited the appropriate response he received from the public protector. Do you recall what that public response was from the public protector?
Not offhand. The public protector was basically explaining why the Section 7(9) notice was publicly made available as well.
That was the response, that she made the 7(9) notice public. And lastly, on this document, right at the bottom of page 3175, it says in the last paragraph, dealing with a serial offender like Gordon, who attacks the public protector's findings on one case, it may be necessary to inform the public about the other serious matters still in the pipeline of investigation. Gordhan has no legitimate constitutional interest in maintaining a reputation or perpetuating his status as a victim based on a false foundation. So, has the Office of the Public Protector done several investigations of Minister Gordhan?
Yes, quite a number of investigations and reports issued against Mr. Gordhan. And this statement is I'm not sure if you're going to ask me, but in essence, it means that he has no legitimate interest in maintaining a reputation. That means that it is as if it's prejudged that his rights to be treated impartially, fairly, and equitably in terms of the constitutional imperatives are non-existent, because he's seen as a serial offender.
Has the office made any findings against Minister Gordhan that has been upheld by a court in final instance that you're aware of?
No, all the adverse findings have been set aside. And recently, the most recent report was unsubstantiated. So there are no current substantiated findings against Minister Gordhan.
Gee, okay. Can I then go to 3178? This is Mr. Siepi then writing to Mr. Ngobeni, and he says, thank you very much for this considered opinion. It must be summarized to 800 to 1,000 words. And then he says, more pressing right now is the reported story that the president has been implicated in the Bosasa matter. It would help to have real facts before one launches into repeating what others have misinterpreted upon reading the statement. Some media have stated that the president has inadvertently misled Parliament. A summary of the key findings will be helpful. Do you see that, Mr.?
Yes, that's correct.
Now, the complaint that was lodged with the public protector, who lodged it? In respect of the president?
I think it was two members, two political parties.
It was the DA and the EFF, correct?
That's correct, yes.
Right. Chair, I'm aware of your constraints. I'm going on to the next item. Would this be a good time to adjourn?
Yeah, you are. Please don't go on to the next item. We will pause there. It's now 1 o'clock. Members have to be in the house at 2, and they still need to go to lunch. We'll pause there, members, and resume tomorrow at 10. Thank you, Mr. Niels van der Merwe. We'll see you tomorrow at 10. Thank you to everybody. The inquiry is adjourned.
Thank you, Chair. Thank you, members.
Recording stopped.